Hello, everybody. Welcome to today's live. So, it's like in the afternoon on Monday. Hope everybody's off to a good week. What is the subject for today? Well, I thought I would talk a little bit about the illegal deportation of the El Salvadorian guy by the Trump administration and what's going on and more or less what we can expect. Okay, and then after I will go back. I will answer what questions you have with the time that we have, and then we'll call it a day. So, what's going on? Well, there was a person from El Salvador that there's no dispute should not have been deported. No dispute by either side. And the excuse that the Trump administration is giving is, oops. I mean, I'm not kidding. I mean, it's a little more than that, but ultimately it's oops. And it went to a U.S. District Court, upon which the judge of that court ordered the Trump administration to bring him back because it was an unlawful deportation. I mean, there's been cases where judges in this type of case have said that what the Trump administration is doing is, I mean, to say it's in left field is to minimize it, okay? I mean, it's just lawlessness. And so the U.S. District Court judge has ordered the Trump administration to get this person back by tonight, okay? And the response of the Trump administration is that they can't do it because they can't get to him. So, in effect, they're pretending that they no longer have the ability to allow this person back in the U.S. And by pretending, I mean pretending, because we all know that if they were to follow the order of the judge, they could easily get this person back. So, what do we have going on here? We have an administration that has flat out admitted to wrongfully deporting someone by oops, okay? We have a U.S. District Court who has ordered the administration to bring the person back because basically we're not a lawless country that just does what we want. We follow the law. And then we have an administration pretending they can't get to the person in order to bring the person back. So where does it go from here? I mean, we could look in the crystal ball. I don't think we need too much of a crystal ball to know that the administration is not going to bring the person back tonight and will sit on their claim pretending that they can't get him back. So then we're going to have a situation where a sitting administration openly admits to wrongfully deporting someone and openly violates an order from a U.S. District Court judge. Openly. Where do we go from this? What remedies exist for the U.S. District Court judge when she finds out, which is going to be tomorrow, that the Trump administration is violating her order? Does she do nothing? If she does nothing, she admits she has no power, and that an order from a U.S. District Court judge is worth nothing, and that we're a lawless country. Does she hold the executive branch in contempt? Okay, I mean, it's a new situation. So it will be interesting to see what she does. I'm almost for certain she's not going to just sit there and do nothing because the Trump administration won't follow the order. And so the real issue I want to see is what type of contempt order will she do to ultimately have teeth in the order and to force the repatriation of an illegal deportation, an illegal, unlawful, admitted deportation. It's not like they're even trying to make arguments that he was properly deported, you know? So I think that she could probably hold some kind of monetary sanctions against ICE or some government agency that actually executed the deportation and continue to accrue those monetary damages until he's brought back. And again, unless the administration wants to pretend like there's no thing like contempt against them and that this judge doesn't have authority and try to do their pretend, they're going to try to impeach the judge type thing, they're going to have to bring this person back. And that will ultimately show that we are a nation of laws, that the administration can't haphazardly deport people because they don't like where they come from. They can't disregard the law because they don't like it. Okay? So that, in a nutshell, is what's going on. So we'll see what happens. Might have an update tomorrow, might not, but we'll see what happens. All right. Let me scroll back, see what we got. Alrighty. Hope everybody's doing well today. Spring is here. Okay. U.S. Citizen Journey Life got the #1 gifter badge. Yay. Okay. Let's see. I know it's late in the day. I think most people are actually going to go start eating dinner, so that's probably why we don't have a lot of questions up to the present point, which is okay. Sometimes I get so many questions I can't finish it, so it's okay. All right, this is from Nisa. A friend is in federal court right now being charged with a felony. He has no prior criminal history. Well, there's no question there, but if he's in federal custody being charged with a felony, that doesn't mean a conviction. But they must have some kind of evidence against your friend to do this. If your friend is not a U.S. citizen, your friend needs to get immigration advice if they're going to try to plead guilty to something. It doesn't matter they have no criminal history. I mean, other than the fact that that makes maybe what they are being charged with less likely to be true if they have no prior criminal history. As far as the federal hold, you need to see if they can get bond. But again, if they're not a U.S. citizen, even if they get bond, they can just be transferred to immigration detention right after. Okay. All right. Is it worth to fight the case? I have no idea, Nisa. I don't know what your friend's being charged with. I don't know if your friend's a foreign national, a U.S. citizen. I don't know what relief they have available. I can tell you, statistically speaking, things are worth fighting for. Otherwise, they're just going to, plead guilty, go to prison, and then be deported for the rest of their lives. That's not a real good alternative to fighting. Okay? All right, my merits hearing is next month. My lawyer found a professor expert witness. Do you recommend using one? Well, first of all, your merits hearing means you're having a trial on an immigration matter. And an expert witness depends on what it is you're applying for. Okay? I mean, your professor could be an expert witness on medieval studies and is not going to help you with your asylum from Guatemala. Okay? So if the expert witness is an expert in whatever it is you're applying for and is coherent, believable, doesn't just come off as saying whatever you want because he's getting paid money, then yeah, absolutely. Absolutely. It's always better to have an expert than to not have an expert. Anything you can have to bolster your case, because nothing is easy to win, okay? Saul got the number 2 gifter badge. Okay. And Skippy doesn't care about activist judges. It has nothing to do with being an activist judge or not. It has to do with a wrongful deportation and issuing orders to make it right. The person was kicked out of the country wrongfully against the law. How do you make it right? You bring them back. This is not an activist judge. This is a judge. Okay? All right. Skippy got the number 1 gifter badge. Okay. Do you do any Canadian immigration law? I don't. I can refer you to a Canadian immigration lawyer, as Canadian immigration lawyers refer their clients to me. But no, you need to go to a Canadian immigration lawyer to do that. Okay. Just a minute. We have someone who asked a lot of questions. Okay. So, just a minute. I just scrolled down and then oh, here we go. I'm back where I was. Yay. Okay. What does it mean oath ceremony will be scheduled? Well, first of all, it depends what you're applying for, but normally the oath ceremony is for naturalization, and normally, if that's the case, you have been granted the naturalization application, and it's when you go to an oath ceremony, you raise your hand, say I do, and you become a U.S. citizen. And Nisa, he's not a U.S. citizen, which I suspect is the case since you're listening to me, and I'm an immigration attorney. He should absolutely fight his case. It just depends on how, okay? He doesn't necessarily have to win 100% to win, okay? All right. Denise, how do I know if I have a permanent bar for more than one entry in the U.S.? Well, first of all, I think you mean one illegal entry, okay? In order to get the permanent bar, you have had to have either been ordered deported or removed, and then illegally entered with a deportation order, or you have to have 2 illegal re-entries. And this, of course, is after 1996. That's how you know. Okay. Denise, you asked that same question like 600 times. What I would do is call my office, and I will give you a consultation and let you know. It will literally take me a minute to determine if you have the permanent bar or not. And if you do, what can be done? If you can't, what can be done? Okay. Can someone that was granted withholding of removal be deported in any way? The answer is yes. They're given withholding of removal because they didn't have enough to win asylum, or they have a crime that was a particularly serious crime that made them ineligible for asylum. And they've shown that there's sufficient evidence that if they go back to their home country, they'll be persecuted. So if the conditions of the home country change to a satisfactory degree, then the government can make a motion to get back into court to withdraw or revoke the withholding, at which point the person can be removed. And the way the administration is working these days, they will try to do that any way that they can, whether there's evidence or not. So if the person has withholding, if I were representing that person, I would see what else they might qualify for and apply for it, like now, okay? Can I come back to the U.S. after overstaying by 2 weeks on my ESTA visa? Well, technically you can because you're not subject to the 3 to 10 year bar. This is for Jacqueline. But the problem is that you overstayed and there is a discretionary part of a decision allowing you back in. And if they don't believe that you're just going to leave, or if they feel that a violation of 2 weeks is not acceptable, they could easily deny your ability to come back on your ESTA as well as revoking your ESTA. Okay? I just got approved APM on DACA. Well, okay. That depends. That you're on. This is Denise. Okay. Yeah, you call my office. I'll help you out. But advanced parole is tricky these days because they're being denied left and right, even if you got it. So I'm advising clients to only go out on advanced parole if they have a super clean case. You don't have a super clean case, first of all, because you're on DACA, okay? And secondly, if you think you're subject to the permanent bar, you might leave on advanced parole and they might deny you entry. And let's say they're totally wrong, which they could be. They're still denying you entry. You're still going to have to go to court and fight the case, and it's still going to be a long time before you can get back. So I would see what you might qualify for and what you might be subject to as to weighing the risks of leaving on advanced parole or not, okay? All right, this is Montar Srilam. I'm Canadian, drove to the U.S. and forgot my passport. CBP said it's fine and waved me and seemed odd. I agree with you. I mean, the way things are today, it's odd that you hit someone who's nice. But you must have had some kind of proof that you're a Canadian citizen. Okay. You must have satisfied them sufficiently. I would say don't forget it in the future. Okay. What type of documents do you bring to your citizenship test? Well, you bring everything that you need to qualify legally for citizenship. So it depends on what basis. Are you doing it on the 3 year marriage to U.S. citizen? Are you doing it on the 5 year? So you have to bring all the supporting documents regarding criminality, if you have any crimes, okay? You have to, if it's the marriage one, you have to show you're legally married, the marriage certificate, you have to show good moral character. So there's all kinds of stuff. Is it safe to go to an ICE check with a holding of removal status? I don't know why you would have an ICE check with withholding of removal. That doesn't make... Oh, thanks for the rose, Jacqueline. That doesn't make sense. An ICE check is when you basically have no status or even deportation status, and they've agreed to allow you to come and check in every 6 months in lieu of deportation. I would be very hesitant, and I would want to know why you have to go to ICE with withholding of removal. And I wouldn't go without an immigration attorney. In today's day and age, is it safe to go to an ICE check with withholding? No. Is it safe not to go if you're being ordered to go? No. Call my office or get an immigration attorney. You got to have one that goes with you. Do not walk into the lion's den by yourself. Okay? Popkin got the number 3 gifter badge. My hub, this is for Lisa. My hub is on, oh, thanks for the rose, Denise. My hub is on an overstayed visa. We haven't filed it for the green card, and we're about to leave. Banned? Well, first of all, I need to see... Oh, well, hi, Romero, thanks for give me 18 roses. All right. Lisa, if your husband qualifies, let's just say he qualifies for residency, okay? And I know what the situation is. Your husband says, "Oh, I can't stand America. I don't want to stay here anymore. Let's just go back to wherever." Okay? Don't do that. Because you're going to go back to wherever thinking that's what you really want to do, and you probably don't want to do that anyways. And what's going to happen is when he gets back there and you get back there, things are not going to be hunky-dory, and you're going to wish that you came back here, and then you're going to be subject to the bar. You're going to have to do all kinds of stuff, whereas right now he might qualify. So the better way to do this is to apply if you can. Call my office. I'll see if he needs maybe a provisional waiver, if he qualifies to adjust. Do whatever's. Thank you, Popkin, for the rose. See if he qualifies. Have him get residency. And then if he still wants to leave and you still want to go with him, then do it. And then he can maintain his residency status by coming back once every 6 months. Okay? It's like going on a trip through the desert and having a bunch of water just in case. By just leaving right now without doing it, it's like going to the desert without any water. You get what I'm saying? Okay. Let's see. Congrats, Romero Fuentes lit up the rose in my gift gallery. All right. Apple eyes. I'm not fearmongering people. I'm telling like it is. Okay? If somebody asks me, is it safe to go to an ICE interview with withholding of removal? Am I fearmongering by telling them the truth that no, it's not safe and that you should have an immigration attorney with you based on the current events? No, that's not fearmongering. Glad we got that straight. Okay. Oh, thanks, Jacqueline. You sent me your first gift ever. Appreciate it. Okay, just a minute. I've heard people traveling on advanced parole with removal orders. You've heard wrong. There is no way on this green earth you're going to travel outside the country on advanced parole with a removal order. It's not happening. Period. Okay? I overstayed over a year. Oh, and by the way, I'm not a TikTok lawyer. I am a lawyer that is on TikTok. There's a difference. Okay. I overstayed a year ago, and I'm trying to apply for a visa now. Will I get denied? Well, or should I contact a lawyer? Well, Jacqueline, yes, you should. Immigration law is like a 10,000-piece puzzle. That's the fact, okay? And sometimes people will go and they'll think they know their everything, but they don't look at all the other things that might happen, okay? I need to see what you qualify for. I need to see what you're subject to as far as inadmissibility issues, and then I would determine a plan of attack to best help you. Yes, you should contact a lawyer. It will only help, okay? It's not like you have to go with them if you don't like them. I mean, if you call my office and I give you a consultation, and at the end of the consultation you say, "Oh, he's full of baloney. I don't believe him. I'm not," well, walk away. But at least if you get the consultation, you will know what the issue is. You will know what you can and can't do, and you'll be in a way better position than you are now. You don't want to just roll the dice, right? Not with immigration law. Okay. All right. Thanks for the gift, everybody. Okay. Let's see. Do we have any more questions? Well, Lisa, you say I already answered it. No problem. Glad I could answer. Oh, you want to leave Lisa, but he doesn't? Well, then In this particular case, I'm sure you win most of the arguments, but in this particular case, you should listen to him. If he qualifies to adjust, then you should do it. Okay? You shouldn't leave without doing that. Give my office a call. I'll let you know what he qualifies for. And then if after you know you don't want to do it or he doesn't want to do it, then that's it. Okay? What kind of status should I apply for? I was granted withholding of removal. You have no status. You're in limbo. Right now, you're in limbo. Okay? That's the point. Thanks for the rose, is Marlon. When you're granted withholding, you're basically you're absolutely in limbo. You don't have any real status here, but then they won't deport you either. So I need. Hey y'all, gonna have to go to Texas. I'm gonna have to see what it is you might qualify for. Like for example, I'll give you an example. Let's say you got withholding of removal because you didn't. They said you didn't qualify for asylum, or your attorney withdrew the asylum, or you didn't get past the 1 year issue, or you were convicted of something shows a particularly serious crime. I would need to review that because maybe you weren't convicted of something showing a particularly serious crime. Maybe you did qualify for asylum. Maybe you didn't file enough to get over the 1 year issue. Okay? That's what I would do. I'd see if you qualified for asylum and go into court on that. Okay. Ramiro. I got my I-130 45 waiting with 601A. Is there anything I'd apply for to get status? Well, you are applying. I mean, the fact you're applying for all this would indicate you don't qualify to adjust status in the U.S., which there's a problem here. You say you applied for the I-485 and you're waiting on the 601A. If you applied for the 485, it means you qualify for adjustment of status, which means you do not need a 601A, which is a provisional waiver, which means when you leave the country, if it's approved, then they've provisionally waived the 10-year bar. You stay out, go to the consulate interview, and come back. So you're not doing this right. Okay, you're not doing it right. Give my office a call. You either qualify to adjust or you don't. If you qualify to adjust, you don't need the 601A. If you need the 601A, you cannot file the adjustment. You need to file consulate processing. Okay? Let's see. Is it okay to this is for Latifa. Is it okay to reschedule the court hearing for removal proceedings while the I-130 is pending for my son? Okay, well, first of all, the court doesn't have jurisdiction to adjudicate an I-130. It's USCIS, and obviously they're taking their sweet time. So it's not a matter of is it okay if the I-130 approval is needed for you to seek relief in immigration court. It's necessary. You need to make a motion to continue, and you need to try to light a fire under USCIS to get that approved. Okay? This is travel. Do I need to contact NVC to pause my I-130 because I have to apply for 601A? No. The I-130 needs to go forward, okay? The 601A comes when consulate processing is in effect after the approval of the I-130. And that's when it automatically is going to get delayed when you file the 601A. Okay. A bet network. Did I pronounce that right? If a fiancé visa got approved, do you have to go through NVC or straight to the embassy? The way the fiancé visa works is once it's approved here, they will forward the approval to the embassy, and then the interview can be set. Okay, and then from there you come in, have 90 days to marry, and then you can apply for adjustment. Okay. Well, I'm approaching the end of the live here. Why? Well, it's almost dinner time, you know. Does one's DUI affect your green card for traveling? Yes. It depends on the DUI itself. I need to see if there's an element of recklessness in there. I need to see what the statutory language is, where it occurred, to see if it makes you inadmissible or not. Okay? So, I think that we have come to the end. I appreciate everybody's gifts. If you want a consultation, just give my office a call. They'll set you right on up. All right? And everybody have a good dinner. All right, I'm off.